violation of monitoring is based upon this new charge. I understand that the state is going to have a stricter burden of proof to establish the charge in this particular case. It's beyond a reasonable doubt. And I understand that given the nature of the charge, domestic violence related, a lot of things can happen between now and when the state gets around to having the case presented to a grand jury because of the fluctuating emotions and so on that occur in these situations. But the allegations here are extremely serious. We often hear cases involving domestic violence, but very few rise to this level where there was not only an attempt to strangle the person by choking them and by attempting to drown the person by holding their head underwater. I find that there are no release conditions that could reasonably assure the safety of this victim at this time. I am not concerned about the defendant failing to appear in court, and I'm not concerned about his release causing him to attempt to obstruct the criminal justice process. I find that the key issue here is the safety of this person. And as of today, I don't find that there are conditions that could reasonably assure her safety. If anything were to change, in that regard, defense counsel certainly knows how to file a motion to reopen detention. But the defendant will be detained for today. I'm still talking, sir. He'll be detained at this point in time. He has 7 days to file an appeal and a right to consult with his attorney. Now, Ms. Donnarumma, your client wants to speak. Do you want him to speak?
Please.
No, Mr.
I would just like to say that there's never at any point in time been a restraining order in effect that would, she is in no danger whatsoever, Your Honor. I would never hurt.
Sir, we're done here. I'm detaining you. I'm detaining you at this point in time. And you can discuss that further with your attorney privately.
Your Honor, please.
Thank you, sir. You may leave the booth.
So what do I do next, Your Honor? I don't know what to do next. I never heard this woman. This woman she's been under the influence of drugs.
Thank you, sir. Your next step would be to contact your attorney so you can have a private conversation with your attorney about what your options are. You may leave the booth for today, and then you can call your attorney at the public defender's office.
I don't have any way to contact them. I'm in jail, Your Honor.
They know the number. Thank you, sir. You may leave the booth. This is State versus Colleen Griggs, and it is Promise Gavel 25-2637. Starting with the state, your appearances, please.
Good afternoon, Your Honor. Jonathan Amir on behalf of the state.
Good afternoon, Rebecca Donnarumma on behalf of Ms. Griggs.
Thank you. And warrant 2025-480-0805 charges a violation of a final restraining order on September 30th of this year. Prosecutor, are you proceeding with the motion for detention in this case?
We are, Your Honor.
And what do you have by way of probable cause?
Your Honor, for the purposes of a probable cause and for the state's application, the state wishes to submit the following. The public safety assessment under warrant 2025-4800805 that was run on October 2nd, 2025 at 8:47 a.m. as S1. The corresponding complaint as S2 containing therein the affidavit of probable cause as S3 and the pleader as S4.
Any objection to these documents, Ms. Donnarumma?
No, Your Honor. Thank you.
Thank you. And Mr. Amira, what would you like to tell us about probable cause?
Your Honor, this case comes before the court based on an incident that occurred on or about September 30th of this year. According to incident reports, which were turned over to counsel as discovery, officers were dispatched to residents in Franklinville for a report of a violation of a restraining order. Upon arrival, the defendant, identified as Ms. Griggs, who stands before the court, was observed on location and appeared to be walking away from the residence. The victim in the underlying matter, vis-a-vis the property owner, is Ms. Griggs's mother. Police were able to confirm that a final restraining order was in effect, and it was issued on or around February 24th of this year and served on the same date, which in effect barred Ms. Griggs from being on the property. And Your Honor, that goes to probable cause for the offense of contempt violating a domestic violence restraining order. Thank you.
Thank you. Ms. Donnarumma, what would you like to say about probable cause?
I have no argument as it relates to probable cause, Your Honor. Thank you.
Thank you. Probable cause is a low threshold, and based upon the information provided here, based upon observations made by a responding officer, I find the state has established probable cause for the charge. The charge is one with a presumption of release. So, Mr. Amira, why should the defendant be detained?
Thank you, Your Honor. The state is moving forward on its application alleging that Ms. Griggs is charged with a crime or offense involving domestic violence as defined in subsection A of 2C:25-19, that she is charged with the crime with serious risk of non-appearance in court, danger to any other person in the community, and risk of, obstructing or attempting to obstruct justice or risk to any potential witnesses or jurors. As Your Honor have found, there's probable cause for a domestic violence offense, in this case being contempt of restraining order. It's our understanding, Your Honor, Ms. Griggs has been charged several times with violating this restraining order prohibiting contact with her mother. The pending matters were recently resolved, and Ms. Griggs has now again offended. I will particularly point to the PSA marked as S1. For starters, she scores a 6 and a 4 for failure to appear new criminal activity. No release is recommended. Your Honor, I am taking into consideration what Ms. Donnarumma indicated off the record earlier. There is a second DV contempt charge. That is not, we agree that is not for the court to consider because it erroneously did not include domestic violence designation. And I would agree that it should be administratively dismissed in favor of the correct charge under the aforementioned warrant 480 as 0805. She has 5 pending charges at the time of her arrest and was previously released on her own recognizance at some point. But the pending charges include contempt, obstruction, DV simple assault, theft by unlawful taking, 4th degree contempt of the DV order. She has 2 prior DPs, simple assault, shoplifting, 11 failures to appear, 2 within the past 2 years. Turning to page 4 of the PSC, there have been multiple instances of domestic violence restraining orders that have been dismissed. Unfortunately, I can't speak to the underlying nature of the restraining orders, but I think it makes it abundantly clear, Your Honor, based on the current one that is active against Ms. Griggs and her mother. We see we have at least one offense date for contempt that goes to September 21st, which was roughly about a week before the present incident had occurred. Your Honor, the state is of the opinion that Ms. Griggs is a danger to her her mother and the safety of the alleged victim. We agree with the recommendation of the PSA and would ask that the court find in favor of detention. Thank you.
Thank you, Ms. Donnarumma. What do you say?
So, Judge, this time I respectfully disagree with Mr. Amira that she is a threat to her mother. Ms. Griggs suffers from mental health issues. She's been before this court numerous times over the course of several years, and because of that, I'm familiar with her and the relationship she has with her mother. Her mother has her children, and when Colleen is doing well, Mom lets Colleen come to the house, which is why we see the prior restraining orders and dismissals in the PSA. They're all related to her mother. And it seems that Ms. Griggs is not doing particularly well right now, and so Mom has asked for another restraining order. I would just ask Your Honor to consider that Ms. Griggs may be a little confused about whether or not she's in fact allowed there in light of the history of her mom seeking the protection and then dismissing it. That has occurred numerous times over the years. What we're here for today, I mean, the danger part is what really throws me off here, that the state believes that there's a danger based on the nature and circumstances of Ms. Griggs and the charge and her, even with the history. Upon arrival, the accused was observed on location and appeared to be walking away from the home. She went to Mom's house. She was told to get out. Maybe something happened. Nothing violent, nothing that rises to the level of it even being mentioned in the police report, and she's leaving. So I think she's demonstrating right there that her intent is not to cause harm. I think she just needs to be reminded in very strong terms that she cannot go right now. Mom has a restraining order and she has to abide by that. I do just want to pick apart the PSA a little bit because, as I indicated before, I got the PSA for the original case, which has been should be dismissed. It's currently still there, so it is being held against her. Any way you look at it, it's being held against her. The prosecutor even just said she was released on ROR at some point. Yeah, that some point was when this complaint came in, and there's an administrative issue there, so she can't be held pre-trial. So they release ROR, but then immediately thereafter serve her with this complaint. So she's never actually been released, Judge. And what's interesting is on the first PSA, she's a 6'5", and then they issued the second PSA with 2 charges instead of 1, and now it's a 6'4". So I don't quite understand why the PSA does what it does. I never pretend to. It's smarter than me. But I do know that the state has not met its burden by clear and convincing evidence to show that she's a danger. There's nothing in this history to support that. You see, there's one DP simple assault that she pled to in 2018, but I would ask Your Honor to look at the date of the offense, which is 2016. So that's some 9 years ago. And I'm sure Mom is the victim, I'm sure. I don't have information to say one way or another, but if I had to guess, she's the victim. But I also see that the things that are pending are all nonviolent, with the exception of one allegation of simple assault back from 2022. And I would just remind everybody that she's presumed innocent on that. So there's a presumption of release. She's here before us on a disorderly persons violation that can be summarized as standing near and on and leaving the property that she's restrained from being on, which is also happens to be the property that she was born and raised in, and that she has been restricted from being there before, then given permission to be before. It's been taken away. It's been given again. I'm not saying she didn't violate it. I just think that she should be released on pretrial and told not to violate again. Thank you.
Thank you, Mr. Amir. Any response?
Your Honor, while I don't believe the pending assault charge involves the alleged victim, it has a Camden Municipal Code. I do note that there were prior contempts or pending contempts, if you will, with offense date of September 21st and September 22nd. And both of those involve the alleged victim. So this is in effect her third contempt with the same alleged victim. Other than that, I have nothing more to say. I think it's abundantly clear she has she shows no indication of being able to abide by a no contact provision because she simply cannot for some reason. I have nothing further.
Thank you. The charge is one with the presumption of release. The state must overcome this presumption by clear and convincing evidence. The facts are not really in dispute here. It's rather simple. The defendant was observed leaving the property where her mother resides, and we've learned today, and where her children reside as well. I do take into account that Ms. Donnarumma is familiar with Ms. Griggs and knows her circumstances, and she has described them for us here today. It was as alleged, it does appear to be a violation of a restraining order. Whether it's provable is for another day. The question before the court today is whether there are release conditions that will reasonably assure the safety of a particular person, in this case being her mother, will reasonably assure the defendant's appearance in court, and reasonably assure the defendant will not attempt to obstruct the criminal justice process. I have no basis to conclude that the defendant would attempt to obstruct the criminal justice process, notwithstanding the two contempt charges that are pending. She does have 11 prior failures to appear, so there is some concern in that regard, but I find that a release condition requiring her to maintain contact with pretrial services would be sufficient to address that. As to the safety of a person, I've heard nothing today at all that would suggest that her mother is in danger of harm. Again, the information on the complaint is simply that the defendant was observed leaving the property. There is nothing to indicate what went on before then, or whether anybody at all was harmed in any way, even emotionally. Just the defendant was leaving the property. Therefore, I find that there are release conditions that could reasonably assure the safety of the community or a specific person, and the state's motion for pretrial detention is denied. It would be my intention to release the defendant, and it would be my intention to place her on level 2 monitoring. Do you wish to be heard on that, Mr. Ramira?
Judge, along with the standard conditions, the state would request that there be a no contact with the alleged victim and to comply with the final restraining order that's in effect. Thank you.
Ms. Donnarumma, do you want to be heard?
No, Your Honor, thank you.
Ms. Griggs, I'm going to release you on these charges. I'm going to tell you about your release conditions, and you'll get them in writing in a court order before you leave the jail today. You're going to be on level 2 monitoring, and that means you have to have contact with pretrial services once every other week. The contact information for pretrial services will be in the court order that you get before you leave the jail today, and they will explain to you how to maintain contact with them. I see that we do not have contact information for you, so in a moment, as soon as I'm done talking, I'm going to put you in a booth with the pretrial services officer, and you can talk to them about how they can contact you. Do you understand that? I'm sorry, did you understand what I said?
Yes.
Okay, thank you. You have to appear for any court dates that you have. It looks like you have a court date on November 20th at this courthouse at 9 a.m. That information will be in the court order that you get before you leave the jail today. You cannot commit any new offenses during your period of release. If you commit any new offenses, that could lead to the state once again filing a motion to revoke your release. You may not possess any firearms, destructive devices, or other dangerous weapons. You shall refrain from excessive use of alcohol or any use of narcotic substances that are not prescribed for you by a licensed medical practitioner. You must comply with the final restraining order, and you may not have any contact with the victim in this matter. Do you understand these conditions?
Yes.
Do you have any questions about them at all?
No.
Ms. Donnarumma, did you want to say anything?
No, Your Honor, thank you.
Mr. Amira, did you want to say anything?
Your Honor, I would just be wondering, and of course with Ms. Donnarumma's consideration, if the court would perhaps consider a condition that they recommend she have some type of mental health and or substance abuse evaluation.
Ms. Donnarumma, your position?
Judge, I object at this time. There's nothing on the record to indicate that that's necessary.
I would agree, although there's been a statement made that there's a history. It could be, we have no idea what it's a history of, so I'm not going to order anything at this point in time. If she appears to be in need of specific services while she's reporting to pretrial services, they certainly can point her in the right direction. So now, Ms. Griggs, I'm going to have you and the pretrial services officer talk privately. You can say right in the booth about how you're going to maintain contact with them. And that concludes your hearing, but stay there so he can talk to you.
Okay, thank you.